Good morning. This is Muhammad Suleiman, Assistant Professor of Commerce, working at MVS Government Degree College, Autonomous, Mehboob Nagar. Today, let us learn about free consent in business laws. As all of us know that a contract to become a valid contract has to fulfill certain essential requirements, and the consent which is given for making an agreement shall be a free consent. Free consent of all parties to a contract is one of the essential elements of a valid contract as per the requirements of Indian Contract Act. All the parties who are giving consent to the offer made for some agreement shall give their consent in a free manner without any pressure, without any coercion, without any fraud, and without any disturbance. So there shall be free consent, which is the willful accord of the parties to the contract. So the objectives of the lesson are: we will be learning about free consent, the introduction part of it, and we will be seeing the meaning and definition of consent. Then we will be learning what is free consent. Then we will be learning about coercion, undue influence, fraud, misrepresentation, and mistake. So let us move on and learn all of these things one by one. So when we talk about free consent of all the parties is one of the essential elements of a valid contract. If the consent given to the contract is not a free consent, then it is not a valid contract. Only when the consent is given as a willful accord without any disturbance or coercion or pressure, then the consent is said to be a free consent. And the parties to a contract should have identity of minds. This is called consensus ad idem. Both parties or all the parties to the contract should think in the same manner. For example, if I have two bikes, one is Hero Honda company make and one is Suzuki company make. If I want to sell my bike, let us assume I want to sell Suzuki make company's bike. If I give an offer to one of my friends to sell my Suzuki company make bike, he should also think in the same manner that I am selling Suzuki company make bike. He should not think that I am ready to sell the bike manufactured by Hero Honda company. If myself and my friend who are trying to make a contract think differently, then consensus ad idem is lost. The consensus ad idem is not present in our thinking. I am thinking to sell Suzuki manufactured bike, but my friend who is ready to buy the bike is thinking that it is Hero Honda manufactured bike. Therefore, both of the parties or both the parties to the contract shall think in the same manner and they should have identity of mind. If they don't have identity of mind, then there is no consensus ad idem and the contract or the agreement made between them will become weak. Therefore, it is important that the identity of minds or thinking of both parties shall be in the same manner. Now, let us see what is consent. When two or more persons are said to consent, when they agree upon the same thing in the same sense. When two persons are thinking or discussing about one article or one phenomena, they should think in the same manner. If they have agreed they should have agreed in the same sense, or if they have disagreed, then they should have disagreed in the same sense. If the parties have not agreed upon the same thing in the same sense, means that there is no contract, because consensus ad idem is not present in that contract. Therefore, the contract cannot be an effective contract. If the contract has to become an effective contract, it will be effective only when there is consensus of mind, identity of mind, or equality of thinking, or consensus ad idem. When it is present, then only the consent is given and the contract will become effective contract. Therefore, no effective contract can come into existence unless the parties are ad idem on all the essential terms of the transaction. If I say I am going to do this, then the other person, the other party to the contract should also understand in the same manner that I am going to do this. Otherwise, there is no consensus ad idem, and the thinking of one person will differ from the thinking of some other person. Then there is no consensus ad idem, and consent given is not a valid one. Now, let us see how consent differs. Absence of consent may arise from a number of causes, like by reason of an error as to the nature of contract itself. While understanding the nature of contract itself, one of the parties or both parties may have different thinking about the nature of contract. In such a case, the consent given is not a valid one, or is not a free consent. Then by reason of an error as to the identity of the party with whom the contract is entered into. If there is confusion, or if there is some vagueness regarding the identity of the party with whom the contract is entered into, then also the consent given is not free. Then one more reason is there: by reason of an error as to the subject matter of the agreement. What they are going to exchange, what they are going to hand over, what they are going to discuss, if it is a matter of confusion or if it is a erroneous one, then the agreement made between them is not a valid one. On this point, we have one famous case that happened between Baladevi versus S. Mazumdar in the year 1956. In this case, an illiterate woman executed a deed under the impression that she was executing a deed authorizing her nephew to manage her agricultural lands, while in fact it was a deed of gift in favor of her nephew, which was not the intention of the illiterate woman. The illiterate woman thought that it was a deed which will authorize her nephew to manage the agricultural land, but the deed was a different one, which was prepared for the purpose of giving gift to her nephew. And later on, the matter was taken up to the court. The evidence showed that women never intended to execute such a gift deed, nor was the deed read and explained to her. Therefore, it was held that the consent was not a free consent and it was a erroneous one. Therefore, it was held that the deed was void and inoperative. Hence, what we learn here is, when the consent is not a free consent, the agreement made is a void one. Therefore, it is important to have a free consent in all the agreements. Now, let us see what do we actually mean by free consent. Free consent is an essential requisite of a valid contract, and it is the consent which has been obtained by the free will of all the parties out of their own accord. They should be willful, they should be free, and they should be they should not be under some pressure or coercion while giving the consent. Therefore, it is an essential requisite of a valid contract. Now, let us see what is Section 14 of Indian Contract Act saying regarding free consent. According to Section 14, consent is said to be free when it is not caused by five situations are given or five reasons are given. One is coercion. When the consent is caused by coercion, then it is not a free consent. Then undue influence. When the consent is taken by putting undue influence, then also it is not a free consent. Then fraud. When the consent is taken by fraud, then also it is not a free consent. Then sometimes it happens that there is some misrepresentation. In this case also the consent is not a free consent. Then lastly we have mistake, which happens naturally with or without intention. Therefore, if the consent is given by mistake also, it is not a free consent. Now let us see one by one about all these reasons. Let us see a coercion first. What do we mean by coercion? Coercion is threat or force used by one party against other for compelling him to enter into an agreement. One person may compel some other person to enter into some agreement. He may use some force, he may use some threat, or he may use some pressure wherein the other party is compelled to enter into some agreement. Therefore, coercion is nothing but the force or threat used by one party and compelling the other party to enter into some agreement. Now let us see what Indian Contract Act says about coercion. According to Section 15 of Indian Contract Act, coercion is committing or threatening to commit any act forbidden by the Indian Penal Code or an unlawful detaining or threatening to detain any property to the prejudice of any person with the intention of inducing any person to enter into an agreement. By taking advantage, one party can threaten, one party can coerce the other party to enter into some contract by showing threat to the property or showing threat to any person, and the main purpose or intention here is to compel the person to enter into some agreement. Therefore, it is important that the consent taken by coercion is not a free consent. Therefore, when the consent obtained with a threat to commit suicide or with a threat of causing a harm to some person comes under coercion, and this type of consent is not a free consent and is not a valid one. Now moving further, let us see what is the essential requirement to say that there is some coercion. An act will amount to coercion if the following essentials are fulfilled. In this case, we have some three conditions. Number one, there must be clear utterance of threat. The person who is putting some coercion should give some clear threat. He should give a threat for not accepting or not agreeing for the contract. Then the threat should be to commit an act forbidden by Indian Penal Code. The act demanded by that person or the activity proposed or supposed to be done by the person shall be forbidden by Indian Penal Code. Then it must be uttered with the intention of causing the other party to enter into an agreement. So the threat shall become the basis, or threat shall become the platform for pressurizing the person to enter into an agreement. Therefore, in such a case, the consent obtained is through coercion. We have one famous case on this point that happened between Chikam Amir Raju versus Chikam Sheshamma. In this case, what happens is by threat of suicide, a person induced his wife and son to execute a release in favor of his brother in respect of certain properties which they claimed as their own. This person threatened them, pressurized them that he will commit suicide if this agreement is not completed, if this agreement is not executed. And they did this because he has pressurized them and threatened them of committing some suicide. Then it was held that the threat of suicide amounted to coercion, and within section 15 and the release of deed was a voidable one. Therefore, the pressure put by this person on his wife and son, and the consent obtained by them was not a free consent. Therefore, the act constituting a threat to commit suicide by that person was held wrong, and the deed was held to be a voidable one. Therefore, it is clear that the consent taken by coercion is not a valid one. Now, let us move further and see what is undue influence. Undue influence is the moral coercion as opposed to physical coercion. It is nothing but domination of a weak mind by a strong mind to an extent which causes the behavior of the weaker person to assume an unnatural character. In this situation, what will happen is the pressure will be exerted by the other party who is in a dominating position or who is in a big or larger position, wherein he will see that the things are managed because of his background, because of his personality, and the behavior of the weaker person is dominated by the stronger person. It is an influence which compels the another person to do something which he would not have done if he had been a free agent. Therefore, his freedom and liberty is dominated by a person who is having a strong mind, and the behavior of the person is regulated, or the behavior of the person is controlled by a person who is in a position who can dominate him. Therefore, such acts are not permitted, and section 16 of Indian Contract Act provides that a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses the position to obtain an unfair advantage over the other. Therefore, this amounts to undue influence, and all such consent that have been obtained by using undue influence are not a proper one. Therefore, the undue influence consents are not called as free consent. Now, let us see the examples where we can suspect some angle of undue influence in making some contracts. Here we can see that undue influence is suspected in the following cases. First one is inadequacy of consideration. Then second one, inequality between the parties as regards age, intelligence, etc. And third one is Pardanashi women. Then fourth one is unconscionable bargains. Let us see one by one. When it is observed that the consideration given in a contract is inadequate. For example, a person who is in a dominating position can make a contract with another person who is in a weaker position to buy his property. Let us assume the worth of the property is 20 lakhs, but the agreement was made only for 2 lakhs. Now we can see there is a huge difference. There is a yawning gap between the consideration given in the contract and the actual value that is supposed to be received if the contract is done with some other person. In such a case, the inadequacy of consideration will raise a suspicion regarding the use of undue influence in case of making this contract. Therefore, if the consideration given in one particular contract is inadequate, then we can suspect the application of undue influence in obtaining the free consent of the party. Then second condition is inequality between the parties as regards age, intelligence, etc. In some cases, it may happen regarding some social status also. Therefore, if the parties making the contract are not equal, if their background, if their personality is not equal in case of or in terms of age or in terms of their thinking like intelligence or in case of their social status, then we can think that there is some sort of or there is some angle of undue influence where the consent obtained is not a free consent. It may happen in some cases that the person who is at a dominating position will make a contract with some other person who is very junior to him or who is very small in his age. The elder person who is a very matured one and elder in age can make a contract with one person who is very young and who is not in a position to decide what is good or bad for him. Therefore, in such a case, the inequality between the parties with regard to their age or with regard to their intelligence may raise a suspicion as to the application of undue influence. Therefore, undue influence is possible in case of inequality between the parties on the grounds of the difference in the age, intelligence, and social status also. Then there is one more reason or one more case in which we can expect some undue influence, that is in case of some Pardanashin women. A Pardanashin woman is one who lives in seclusion, having no communication with the world at large except from behind the screen or parda with any male person except a few privileged relations in the family. Therefore, she will not have, naturally, she will not have much contact or awareness in the outside world. So, in such a case, there is a possibility of giving some inadequate consideration, or in such a case, there is a possibility of giving low value than what is actually required. And law also provides special protection to Pardanashin ladies on the grounds of their being ignorant so far as the world at large and the knowledge goes. A contract with a Pardanashin woman is presumed to have been induced by undue influence. She is not bound by the contract unless the other party can show that it was her intelligent and voluntary act to enter into contract. Therefore, where a deed is executed by a Pardanashin lady of considerable age, it is on the part of the opposite party to prove that the lady really understood the contents of the contract, the lady really understood the terms of the contract and intended to execute the deed. Therefore, there is a possibility of use of undue influence in case of some Pardanashin women also. Then we have one more case where we have some suspicion regarding undue influence, that is in unconscionable bargains. Unconscionable bargains are nothing but the bargains with some unfair intention, where one party in a contract can dominate the will of the another party and the contract is apparently made as unconscionable contract where some unfair intention lies on part of the parties to the contract. And these type of bargains are witnessed mostly in money lending transactions and in making some gifts. There is one famous case in this unfair bargains which happened between Kirparam versus Samiuddin Khan in the year 1903. In this case, a youth of 18 years of age spendthrift and a drunkard borrowed rupees 900 on a bond bearing the compound interest of 2% per month. And later on, it was felt that the interest was very high, and the matter was taken up to the court, and the transaction was felt to be unfair, and it was held by the court that the transaction is unconscionable and the rate of interest charged being so exorbitant. Therefore, the contract was held as unfair contract because of the rate of interest that is being charged, that is 2% per month. Therefore, uh, undue influence, undue influence put to obtain the consent is not a free consent one, and the uh, contract that have been made or the agreement that have been made are not a valid one. Therefore, the contracts made or the consent obtained with coercion and undue influence are not a valid one. Here we have to differentiate between coercion and undue influence. Sometimes we may feel that both of these are one and the same, but there are some differences that exist between coercion and undue influence. In both the cases, it is observed and accepted that the consent is not a free consent, or consent is not given on voluntary basis, but the contract is viable at the option of one of the parties. Now let us see one or two differences or points of distinction between the coercion and undue influence. Coercion involves the use of physical force, while undue influence involves the use of moral pressure. In coercion, the threat may be a physical one or physical pressure, but in case of the undue influence, the pressure is a moral one. And in case of undue influence, second point of distinction we can see, in case of undue influence, there must be certain relationship between the parties which places them in a position where one dominates the other one, or the stronger person will dominate the weaker person. But in case of coercion, there shall not be any relation, or the relation between these persons is not needed, wherein the pressure is made on one person who may be a stranger also. So, unlike undue influence case where there must be certain relationship between the parties. If the relationship between the parties does not exist, there shall not be undue influence. But in case of coercion, it is not necessary that there is some relation between the parties wherein they can have pressure on them. Therefore, one more point we can see, that is a point of distinction between coercion and undue influence. Coercion involves a criminal act, while there is no criminal act in undue influence. Every time there is no criminal act or criminal intention in case of undue influence, wherein the stronger person dominates the weaker person, but coercion being a physical force, being the use of physical force, involves some criminal intent. Therefore, these are the differences between the coercion and undue influence. Let us move further and see what is fraud. Fraud is nothing but it is a situation wherein one person deceives the other person. It includes all acts committed by a person to deceive another person. It can be making false statements made knowingly or without belief in its truth, or it can be made recklessly also sometimes. Therefore, fraud is also one of the grounds wherein the consent taken is not a free consent one. And according to section 17, fraud is defined or explained in many ways. For example, a false assertion as to a fact known to be false or not believed to be true, telling something other than the actual position is also a fraud. And secondly, it can be the active concealment of fact, the having one knowledge of belief or fact. And sometimes it may happen that a promise made without any intention of performing it is also considered to be a fraud. And any other activity that is purposefully or intentionally taken to deceive one person is also a fraud. Therefore, we can observe that there is some sort of malified intention in case of committing a fraud between the parties to the contract. Therefore, if the consent is obtained with the fraud, then also it is not a free consent. Now let us see about misrepresentation. What is actually misrepresentation meant by, and we will see how misrepresentation will go wrong when consent is taken by one person. Misrepresentation is nothing but a wrong representation when made innocently. Sometimes it happens that a person without any malified intention, a person without any wrong intent makes some presentation or projects something which is misrepresented. For example, a false statement made by a person either willfully or innocently can be treated as misrepresentation. And a misrepresentation when made innocently is called innocent misrepresentation, and when misrepresentation when made purposefully or fraudulently, it is called a fraudulent misrepresentation. Fraudulent misrepresentation is a intentional one, whereas the misrepresentation without any malified intention is not is a innocent misrepresentation. Now let us move on and see how misrepresentation of one particular case can be decided. To say that there is some misrepresentation, we have some essential requirements. Those essential requirements are: there should be a misrepresentation or assertion. It must be very clearly defined, or it must be very clearly understood that there is some sort of misrepresentation done in one particular case. And the second condition is such representation must relate to a matter of fact which has become untrue. So it should be detected, or it should be traced at a later stage that the representation made by one of the parties or both of the parties to the contract was not true or was not correct. And the third one is it was made before the finalization of transaction with a view to induce the other party to enter into a contract. This happens naturally most of the times, wherein in order to induce a person to enter into a contract, misrepresentation is made by one of the parties to the contract, or in sometimes many parties to the contract. The intent or objective here will be to pull that person or to induce that person to make some contract, and if it is detected before the finalization of the transaction, then it will be treated and it will be understood as misrepresentation. Then one more essential requirements of misrepresentation is it must actually have been acted upon by the party. Only the parties to the contract, for example, if A and B are transacting for making one particular contract, it should have been done between A and B only, and no other person not related to the contract should have been involved in misrepresentation of the case. Then one more essential requirement of misrepresentation is it must have been made either by the party himself or by his duly authorized agent. If a person, I repeat here, if a person who is not at all related to the contract or who is not a party to the contract has misrepresented something, then it is not a matter to be taken very seriously, or it is something which is to be ignored. But when a person who is actually a party to the contract or any authorized agent of one of the parties to the contract commits some misrepresentation, then we have to take it very serious, and we have to think about some angle of fraud or angle of some uh, loss in case of misrepresentation. Now let us think about consequences of misrepresentation. When misrepresentation has happened, what is the possibility of bringing loss to one of the parties or both of the parties to the contract? When a misrepresentation has been made, the aggrieved party may have some alternative choices in order to secure or protect himself against some loss. One option that he can make is he may avoid or rescind the contract. He may try to avoid the contract in order to stop loss, or in order to ensure himself that he is not suffering a loss. Or if he does not want to rescind the contract, he may affirm the contract and insist on particular performance. He may explain the matter to the other party, and if it is not a fraudulent misrepresentation and if it is an innocent one, it can be corrected, and misrepresentation being made can be cleared and it can be made good also. In that case, what happens is the contract moves further, and the contract will become a good one and the misrepresentation done will be cleared. Then third one, he may rely upon the misrepresentation as a defense to an action on the contract. He may take some action against the contract just on the basis of misrepresentation, and he can take some against the misrepresentation that he has been faced. Having seen fraud and misrepresentation, it is important that we shall compare these two and see whether there is some distinction between misrepresentation and fraud. We know that fraud is very clear case of wrong intention or modified intention, wherein a person is deceived. So all the times in case of fraud, there is some intention to deceive a person. But in case of misrepresentation, there may not be every time an intention to deceive a person, because misrepresentation can be an innocent misrepresentation, and sometimes it can be fraudulent misrepresentation. Therefore, in case of fraudulent misrepresentation only, there is some angle of deceiving the other party in the contract. Otherwise, in other cases, there is no intention to deceive. Therefore, the first distinction between the fraud and misrepresentation is a false statement made with an intention to deceive the other party is fraud. But in case of misrepresentation, a false statement even without any intention to deceive the other party would be misrepresentation or would lead to misrepresentation. Therefore, fraud is different and misrepresentation is different, or the intention behind the fraud is different and the intention behind a misrepresentation is different. Now let us see on facing of fraud or on experiencing of fraud and misrepresentation, what are the possible course of action that the other party may adopt. In case of fraud, the aggrieved party has a right to claim damages because the fraud is already done and he is facing some loss. Therefore, he can take the matter to the court, and the aggrieved party has a right to claim some damages. But in case of misrepresentation, the party can avoid from entering into the contract. He can simply rescind the contract, or he can simply ask the person to cancel the contract as there was some misrepresentation. If the misrepresentation is clear, or if the thing which is given in the false mode is cleared and it is made correct, then he can think of continuing the contract. Then in case of fraud, third point of distinction we can see, in case of fraud, a fraud may amount to an offense of cheating, but misrepresentation only gives a right to avoid the contract. Or put it in other ways, fraud is a criminal act. It is having some criminal intention, and the person involved in the fraud is called a criminal. But in case of misrepresentation, every time it is not a criminal act and misrepresentation will give a right to the person to avoid the contract. Therefore, like this, there are many differences between fraud and misrepresentation. We have discussed just two or three which are important for us. Having known misrepresentation, now let us see about mistake. What is actually mistake and how it may happen. So now let us see that mistake is an erroneous belief concerning something. It means that parties intending to do one thing have by intentional error done something else. So it may be defined as an erroneous belief. An erroneous belief wherein the parties intending to do something have done something else. Therefore, mistake is mistake and it may be of two types: mistake of law and mistake of fact. So the person may commit mistake in understanding the law properly, or he may commit mistake in understanding the fact of the contract. Therefore, mistake can be understood from two different angles. One is mistake of law and the second one is mistake of fact. Now let us see what is mistake of law. Mistake of law may be of three kinds again. So it is mistake of general law of the country, wherein a person is not in a position to understand the general laws of the country in a clear manner. Therefore, he may commit a mistake of understanding of general law of the country. Then second one, mistake of foreign law. A person who is trying to enter into a contract with some foreigner may commit a mistake in understanding the foreign law properly. Therefore, the mistake of foreign law can also happen. Then one more mistake that is possible is mistake of private rights of a party relating to property and goods. One person may not be in a position to understand the rights of a private party in treating the property and goods. Therefore, every person is supposed to know all these things and is not supposed to commit any mistake, because ignorance of law is no excuse and is applicable to all parties who are signing the contract. And the contract is binding because everybody is supposed to know all these laws that are related. Therefore, mistake of law can happen in three kinds: mistake of general law of the country, mistake of foreign law, and mistake of private rights of a party. Then a second type of mistake that may happen is mistake of fact. Mistake of fact may be either a bilateral mistake or mistake of only one party, that is unilateral mistake. When both parties to the contract think differently, when the facts in the minds of the both parties are not correct, or they have negatives and there is no equality of minds, and the matter or the content of the contract is understood differently by both the parties, where both the parties to the agreement are under a mistake as to a matter of fact essential to the agreement, then the agreement is declared to be a void agreement and such agreements will not be accepted. Therefore, the mistake made by both parties are called bilateral mistakes. If the mistake is only on one side, or if only one party to the contract is not in a position to understand the content or facts of the contract properly, then such a mistake is called unilateral mistake, and that mistake may be on various grounds wherein one person is not in a position to understand the terms of the contract properly. It could be because of identity of persons and the mistake committed on thereon, or it could be a mistake as to nature of the contract itself, wherein the person is not in a position to understand the facts of the contract. Therefore, mistake sometimes will uh, lead to absence of free consent in a contract by making the contract a void one. Thank you.